Oh, hi everyone. Thanks for coming along this afternoon as we cover some of the employment law topics and issues that have been put to us to run through, I guess, in the context of this lockdown and shutdown of the construction industry, the unprecedented shutdown of the construction industry. I'm joined by one of our amazing lawyers, Marianne Wen. Hi, Marianne. You're online now?
Yeah.
Hi, Marianne. If you can shoot your camera on and flick to the next slide, I'll sort of give people a rundown about what we're talking through this afternoon. So just next one along as well, I think. So I guess what we're wanting to jump through today is really sort of talking through the what some of the things to think about in terms of what this construction shutdown means, what some of the options available are going to look like, and what some of the resources are going to be around that. Now, originally, just for some context, originally one of our senior employment partners, Jacqueline Fenby, was going to be running this. She's unfortunately lost her voice, so she apologises she can't do it. So you've got Marianne, who's again one of our excellent lawyers in the employment law team, and I've stepped into Jacqueline's shoes. Employment's not my everyday practice, so I'm going to start with an apology around that. So if there is anything I don't cover well enough, or things you want to ask questions about, please put them in the Q&A and we'll try and cover them today. But if we can't, we try and put out our responses to Q&As and some general fact sheets following these webinars. So I do want to apologise, Jacqueline is unavailable, and I'll do as best I can, and I'm sure Marianne will be able to take you through most things. I also apologise. I've got a medical appointment myself at 3 o'clock, so I'm working from my car. So that probably gives the context of why it's a bit of an unusual background around me. But jumping straight in, and if you have any questions as you go, please just put them in the Q&A, and I'll try and monitor and respond to those either at the end, or if it makes contextual sense to respond to that as we go through. So the main things I'm going to be looking through is the impact of the COVID-19 on employers and businesses, talking through in a bit of detail the concept of stand downs, talking through redundancies and what other alternatives might be available, then looking at some of the other programs and changes to the awards. So next slide. Yeah, great. Thanks, Marianne. So big one. I guess we've talked through a lot of what was covered in the earlier webinars. A lot of what came out of the pretty intense press conference and orders made by the New South Wales government on Saturday. But one of the big ones is they've included pretty significant penalties for employers who force their staff to attend non-essential workplace when they can reasonably work from home. So that's up to a $10,000 fine. And the language around that has just shifted again. Marianne and I have been monitoring. Marianne, what was the latest change around that language that sort of happened over the last little while?
They've used the wording of must allow rather than must require, and they've confirmed that the working for 7 rules don't apply to Newcastle and the rest of regional outside of Greater Sydney. I think that's
right. Yeah, so that's a clarification. It looks like it's really come through this afternoon, and the language on the website has shifted over that last little window. So I think that's from an employer perspective, that's a bit of a safer position than what we previously had around must require versus must allow. So the obligation is giving them that opportunity to work from home and being flexible to do so, rather than pushing all your employees to now work from home. The other follow throughs are Fairfield, Liverpool, Canterbury, Bankstown, local government areas. You can only leave to go to work if the business is allowed to be open and you're an authorised worker. Now, the businesses that are allowed allowed to be open are dealt with on the newsouthwales.gov.au COVID rules website. So please go there, particularly the limitations around retail. But we're talking in the construction context at the moment, so a lot of your businesses, unfortunately, are being pushed into shutdown from here. So jumping forward. So the stay-at-home rules apply to Greater Sydney, including Blue Mountain, Central Coast, Wollongong and Shell Harbour LGAs. Only allowed to go to work if the business you work at is allowed to be open and you cannot work from home. And from the 18th, only retail premises providing essential goods and services were allowed to open. The exemptions were really around providing services to vulnerable people. So those are probably where the rules sit at. What we really wanted to cover in a fair bit more detail today was what the impact of the shutdown in the construction industry is going to really have on employers in the construction industry, because the impacts, I guess, felt in New South Wales in particular over the course of last year weren't as far-reaching as what's come to life this week. And we're speaking with a multitude of businesses from mum and dad trades and home builders right through to some internationals, large contractors, people running tier one projects, and everyone's really feeling a lot of stress off the back of this. So and people that are managing teams and managing workforces, whether that's again an apprentice and one admin, right through to where you've got teams of hundreds of people, are really struggling to get on top of what options might be available to them. So I'm going to put it across to Marianne, and she's going to, I guess, talk through what some of the impacts of COVID-19, particularly the latest shutdown that's happened in the last week, are going to have for some employers.
Thanks, Mike. So the main impact that we're seeing is this request for a flexible working practice. With these new health orders, we're seeing a bit more of a hybrid working space where people are working from home or working from the office. So one of the main things is ensuring that as employers, there is a duty of care to provide a safe work environment that applies both at home and in the office. We're finding out a lot of our clients are asking for more detailed policies, and that's leave policies and COVID policies as well. In particular, in times where things are quite unprecedented, it's good to have detailed internal processes in place. So we're finding a lot more impact as having those detailed documents. I guess one of the main things is business continuity, the lack of work, the requirement to cease work, and how that will affect the practices of the business. So we're dealing mainly around that aspect. But the main thing, I guess, to ensure through these times is not breaching other employee protections while trying to maintain all the risks.
Can you explain to me what you mean by that, Marianne? So what are the employee protections that we're really starting to talk about there?
So at this stage, it's been like making sure it's free from discrimination, being aware of other workplace rights. We're finding a lot of people are getting reduced hours, so which would have to amend their current employment contract. So it's ensuring that, it's free from undue influence or pressure when trying to negotiate on these new terms and arrangements.
Yeah, oh, that's great. And I think one of the things we've talked about quite extensively is when you move in this workforce from, I think it's really important the government shifted the language from must require to must allow. When we're working with a lot of employers during COVID last year, that people did have employees that couldn't build a safe work environment in their usual home. And, that could have been because of domestic violence issues. It could have been just, how their home environment was set up. So shifting that to allow people to, employers to allow workers to work from home as opposed to pushing their workforce into the homes, I think is a pretty important shift. Do you agree, Marianne?
Yeah, and in terms of the safe work environment, there's a lot of resources out there that can help. Safe Work New South Wales has a really detailed checklist when people are working from home, and it's small things that you don't even think about, like having a first aid kit at home. It's just ensuring that utilize the resources out there to help as well.
Yeah, there's some checklists that we've previously built, and we'll try and circulate it with the material from this around some of those things you might want to deal with as an employer in terms of double checking that people are safe. There's also some online ones, Marianne. Sorry, you and I haven't worked through everything in complete detail. We're running these through pretty quickly, but there has been some really useful checklists put up by industry bodies as well as I think Safe Work from memory around what to look for when working from home.
Yeah.
Yeah. A couple of questions starting to come in already. I might shoot through those as we touch on everything. So I'm a design builder with one home office on the Central Coast and one show home office in the Lake Macquarie region. Are we able to work design and architectural in the Lake Macquarie office? I'll have a go at answering this first, and Marianne, if you have a competing or different view or more comments, please chime in. I guess for everyone that's logged in, we're trying to run through these webinars pretty quickly, trying to put material together pretty quickly so it is useful. And I guess I also add that it's not legal advice. We're just trying to cover off on these legal issues for you as best we can. So if some things are a bit rough and ready, for example, me working out of the car, out of the back of a doctor's car park, it's because we want to try and get the information out and give you some currency to help address these issues as quickly as possible. But the question about the home office on the Central Coast and home office in Lake Macquarie, my understanding is that there shouldn't be any issues from people working from the Lake Macquarie office if they're in that region. People that are in the Central Coast office shouldn't be able to travel to the Lake Macquarie office and should be allowed to work from home, with the preference being that they work from home and not in the office. Marianne, did you have any further comments or different thoughts to that?
I agree, and it's also whether it's reasonably practical for someone to be able to work from home if they can't. But I think it's the regular stay-at-home orders in terms of the Greater Sydney, which includes the Central Coast.
Right, thanks, Marianne. So the big questions, I think another screen's just popped up in front. If you can shut that, yep. The big issues that have been asked for us is, when you've got a reduced business, how do you deal with the level of work for employees? The concept of standing down employees and making employees redundant. And they were the big ticket questions that came up during, March and April last year that have continued to come up with businesses we've worked with interstate. Unfortunately, it's been something that's been facing a lot of businesses in Melbourne and Victoria, more than New South Wales. And they're things that it was really unprecedented dealing with it for the first time last year. So we've got a bit of clarity around this, and I guess we're just going to sort of work through these one by one, Marianne.
So the first alternative is standing down employees. So under Section 524 of the Fair Work Act, you are entitled to stand down employees if three elements are satisfied. So when an employee cannot be usefully employed, or there's a stoppage of work for any cause or industrial action, breakdown of machinery or equipment, or for which an employer cannot be held responsible. So the last element is a lot more applicable, I guess, in this case with COVID, where it's out of the employer's control. One of the main issues in figuring out whether you're entitled to stand down employees is whether opportunities for employees to be usefully employed. So the wording around usefully employed is work that they're capable of undertaking, even if that's outside of their usual duties. And there must be a causal link between the stoppage of work and the impact of COVID. So it's not enough just to say, hey, we've got a bit of a downturn at the moment. There must be a stoppage of work. The main thing to do in terms of standing down employees is check your enterprise agreements in your contract of employment. And sometimes in any applicable modern awards, there could be additional obligations such as consultations. And as an employer, you've got to be fair and reasonable in any decisions that you make. So if a stand down is unlawful, there could be quite significant consequences to the employer. So, you'd have to backdate the employee and they would have a right to return to work. And during stand downs, one of the main questions we ask is, does the employee entitlements continue to accrue? Yes, they do continue to accrue, but there has been some case authorities in terms of what leave you're entitled to utilise while you're being stood down. So there's been a recent case, the Qantas CEPU and the Qantas Airways, where they said that you cannot utilise sick leave, carers leave or compassionate leave while you're being stood down. That doesn't apply to any annual leave, long service leave or paid leave under any entitlements under the awards.
Right. I think, I mean, Qantas has really paved the way for sort of understanding what the law around standing down employees in Australia looks like. I'm sure they would have preferred not to have had to do that, but I guess given the airlines were the first things that really dramatically felt the impact of COVID in the last, well, we're coming up to 15, 16 plus months now. Qantas was at the forefront of, I guess, working out what, standing down employees. It wasn't something that was regularly done in Australia. This isn't an area of law that was tested in the same way as some other areas of employment law before we trekked into the COVID territories last year. One of the questions, I am going to try and cover these as we go along, and if I don't give a perfect answer, again, apologise. I can run it past Jacqueline, who leads the team, when or following this, and get back to people in our more comprehensive answers and material tomorrow. For construction companies, are they allowed to redeploy staff from the Central Coast Sydney region to work on Newcastle sites? The sites in Newcastle is not the normal region they would cover. That's really going to come into the context of the orders in Sydney around whether people can or can't leave the region. Marianne, do you agree?
Yeah, definitely. And I guess it's ever changing. It's even changing just today on what's in regional in Newcastle as well.
Yeah, I mean, on the face of it, my initial view is because of and I'm just going to pull up some material as I talk to you, in terms of the what the government said about reasonable excuses to leave the Greater Sydney region. I don't think you're going to have to apply for an exemption to be able to do that, and to deploy staff there. So if staff may not be able to be redeployed from the Central Coast or Sydney to work in Newcastle, on Newcastle sites, we will look into that in a little bit more detail, because the material from the government has been shifting, and there's the commentary around that has been shifting. But on the face of it, my initial view is probably going to be a no there. Marianne, did you think otherwise?
No, I agree with that.
Yeah. So yeah, I guess rolling into stand down, it's something that's pretty fresh, and it really does involve quite a degree of planning to be able to do this properly. It's not a matter of just suddenly sending out a notice and going, you're all stood down. There's a lot of factors, and particularly those three critical factors that employers need to look at and work through before they make that decision. And we appreciate that process has to happen, but it might have to happen very quickly. Marianne, did you have any further thoughts around that?
No, I just wanted to also add that if an employee can challenge a stand down if they consider it unlawful, in which case then, it'd be up to the Fair Work Commission to make a ruling on that. But you could be up for the penalties for the Fair Work Commission if it's considered unlawful. So yeah. Can't be done.
I think if you can there is an opportunity to move pretty quickly on this if you're an employer, and we're happy to give some further advice around this. But given the breadth of the construction shutdown, I saw that at around 12:30, 1 o'clock, they were saying that they hoped it would only continue to the end of this month or to the end of next week, really. But there's no certainty around that. So it may very well be that if you want to stand down because you can't. Because the work has clearly stopped. The stoppage comes off the back of the COVID, off the back of the COVID orders. I can't see any construction employer has been held responsible for that stoppage. And if you can't redeploy them or use them elsewhere in the business, there is that opportunity to consider a stand down. It is really important to make sure you have the mechanisms in place to continue to allow them to accrue the relevant entitlements, but you also need to be able to show the process that's associated with coming to that decision to stand down, particularly should the decision be challenged at any level. Okay, I guess we jump into redundancy here, Marianne.
Yeah, so one of the main factors, I guess, when dealing with the redundancy is ensuring that it is genuine. So for a genuine redundancy, the job is no longer required to be performed by anyone in the business. So, you know, we find that this happens when there's a change in operational requirements in the business, when the department gets is no longer required. One of the main thing about the redundancies are that usually applicable modern awards quite detailed obligations on consultations. It might also be relevant in your enterprise bargaining agreements as well. So the consultation obligations would be, you know, ensuring that you're consulting the employee throughout the process and letting them be aware if there's a material change in your business that could affect their employment or hours. So the main thing is ensuring that if there is a genuine redundancy, there's opportunities for redeployment within your business. So of this particular example, we had an international client who, you know, I was closing down a department in Australia, but it wasn't unreasonable in the circumstances to consider redeployment opportunities overseas, because it also relates to your related entities as well. So it doesn't necessarily mean that it could be within their skill set. In circumstances where it would be unreasonable to redeploy them in a different role, then in which case it would likely be a genuine redundancy. When you're implementing a genuine redundancy, definitely consider any consultation requirements. The Fair Work Act in the modern awards usually set out the redundancy pay. So it's ensuring that it's the right amount and any notice requirements are provided. Your contract as well usually would have, you know, what notice periods you have to give for terminations or payment in lieu. It's just being on top of that.
Yeah, and I guess the same thing goes here. I think it's really important that Marianne's emphasised it's not an opportunity to clean house. And we did see a bit of that during the initial stages of COVID last year, the phone calls from employers saying, hey, look, I've got these dud people, can I just get rid of them now? And it's not as simple as that. I mean, one of the questions that comes up, Marianne, is when things like this happen that have such a dramatic, far-reaching implication on certain businesses, and redundancy really needs to be put on the table. So, for example, some businesses might be looking to do a bit of a wholesale restructure over the next couple of weeks. How quickly do you have to? Can you expedite that consultancy process, or how can you approach that in a better way?
Look, I think the more time you give is better. Usually in the modern awards that I've looked at, it's just providing reasonable notice. So, you know, in circumstances, I appreciate things are just moving so quickly that things might not be reasonable, but it's ensuring that even if, you know, if you have the opportunity to give 2 weeks rather than a week, you know, it's ensuring that as much time as possible is given to the employees. Again, there is no sort of minimal time frame, but the longer the better.
One of the questions that's just popped up, and we'll circle towards this, are our full-time apprentices entitled to apply for government grants as they have 2 weeks no work, and can they choose not to take their holiday pay? Look, I'll look into that a little bit further. It's going to really depend on how those apprentices are engaged as a starting point. So if they're done through, for example, I know the master builders and the HIA, for example, put a lot of apprentices on within businesses. Look, I'm going to have to look into that a bit further. Marianne, did you have any thoughts? But it's a good question. It's one we might cover in the Q&A. They're direct employees. I just saw come up.
Stand down notice.
Yes, I'm not sure if you know stand down whether they can apply for government grants. If they're direct employees and you're not standing them down, you continue to pay them as usual. If they're direct employees and you're not able to deploy them in any other role, you might want to consider the stand down option. I haven't looked into, Marianne, you'll cover at the tail end, I haven't looked into in any great deal how the government grants are working in that context, but it's something we will cover off. But you probably, of what you're describing in these comments, you might have an opportunity to use the stand down, and that might open up some access for them to some of those grants. But we'll look into that a bit further. It's a good question. I'm sorry I can't answer it more fully at the moment.
My understanding is under the stand down provision of Fair Works Act, there's no legal entitlement to pay the employees. But my understanding of the government disaster payment is that you can't take leave and also be entitled to the payment, so you actually have to lose hours. I think we've dealt with that as well here. Sorry, in the next slide, which is the alternative to redundancy or standing down. You're allowed to have the option of providing the employees access to the accrued annual leave or long service leave, but where it's not possible, there is the option to elect for leave without pay. But yeah, sorry, that sort of answers the question a little bit as well.
Yeah, so we will cover that in a bit more detail in the Q&A. I think it's a really good question, and appreciate it. So thank you. I guess, yeah, so having looked at redundancy and stand down, what other options might be available to employers, Marianne?
So the variation by agreement, that's one of the options we're finding a lot last year in terms of the COVID, and that's just even a variation to the contract to reduce hours, or even documenting whatever hybrid working model that you're working from, either half working from the house or half working from the office, reduced remuneration in terms of reduced hours. So, a lot of it, I guess the main thing is not having undue influence on the employee to arrange for the contract, but both parties agreeing to arrangement that suits.
I guess that's the most important thing. It's one thing we had to cover in a fair bit of detail last year when this when the shutdowns first started, or when COVID first started to have an impact. Agreements can't be unilateral. So you can't turn up to an employee and say, I've decided to reduce you to 50%. Here's the agreement, sign it. There has to be an agreement has to be reached. You're going into the scenario where, as the employer, the powers rested more with you than with the employee. So there has to be a degree of consultation and engagement to reach a genuine agreement around this. Do you agree with that, Marianne?
Yeah, definitely.
Yeah, so that's probably the biggest thing. A lot of these, and I know it feels a bit tedious and can feel like it's a bit of overkill, particularly with the urgency of some of the decisions that are getting made. But even if it's a rapid consultation process, you need to be able to work through things and show that process. Like, that's really critical. The consultation with the employees, the engagement with them, the putting options, the relevant options on the table, whether, for example, whether you're looking to do stand down, whether you're looking at potentially doing a restructure that leads to redundancies, or one of the big things we did see done a lot last year was that wholesale adjustment to people's workforce by varying them down to, say, that 80% of hours. Stand down does feel like a good option for a lot of businesses we've spoken to with this construction shutdown, because there is really no opportunity for any other work for a lot of employees to do within the business. There's, I guess, and where that wholesale restructure is, sometimes the redeployment doesn't look necessary. Again, it's working through this properly and in some detail, even if you're doing it rapidly, and having, again, we're not giving legal advice, but one of the things we always find really useful when it gets to this is having the availability of contemporaneous records and notes and things that show the process. Engagement with the employee, whether it's over email, ideally you're doing things in writing, keeping some degree of record keeping, like file notes from when you're having these conversations with employees. Marianne, obviously you do a bit of litigation in this space as well. All those live records become really important.
Yeah, just makes a world of a difference, just having a good paper trail.
Yeah, great. So what we're going to run through now is a bit around the grants that might be available to businesses and employers. We're going to shoot through this pretty quickly, because we'll touch on some of this again when we get Dan Mills from William Buck speaking with our team around some of those corporate obligations, as I'll frame it on Thursday. But Marianne will run through some of these in a little bit of detail to get started.
So there's currently a 2021 COVID-19 business support grant. This is now available for application. So this is a support package for businesses, and its aim is to help as a one-off payment to help businesses through the first 3 weeks of lockdown. So from the 19th of July, eligible New South Wales businesses, sole traders and non-for-profit organisations can apply up to $15,000 on this grant. There are further assistance from 26th of July, which we'll touch up on. Whilst those applications are not yet open, you can register your interest through Service New South Wales. So with this COVID-19 business grant, the eligibility is you're a New South Wales business that has a turnover of more than 75,000 and up to 50 million. You'd have to have a total annual wage bill of below 10 million. So we've just set out there the amounts with the decline in turnover. So 70% or more is 15,000, 50% or more decline in turnover is 10,500, and 40% or more is 7,500. And like I said, you can apply through the Service New South Wales app. The Job Saver is available from the 26th of July. These are fortnightly payments to help maintain employee headcount. So the headcount is as at 13 July, and its aim is to provide cash flow support for businesses. So if you're an employing business, you can receive 40% of your weekly payroll. That's a minimum, with at least a minimum payment of $1,500 per week and a maximum payment of $10,000 per week. So if you're a non-employing business, you will receive $1,000 per week. So the eligibility for this grant is that you have revenue decline of 30% or more, and your turnover is between 75,000 and 50 million. So the micro business grant is for smaller turnover. These are fortnightly payments to help businesses with turnover between 30,000 and 75,000. So it will equate to about $1,500 per fortnight. You'll be eligible for this if you have a turnover between 30 and 75,000, a revenue decline of 30% or more, and your business will have to be a primary source of income for a person that's associated with that business.
Marianne, one question that's popped up from Brett. When are we measuring the revenue decline from? So what's the revenue decline compared to?
I'm not sure of that answer at the top of my head, sorry.
That's okay, Brett. We'll cover it in the notes that we send through afterwards. I apologise for not on. We're sort of trying to work through this pretty quickly, and I'm not sure all of this has been clarified as clearly as we'd like either by the government. So we will try and get that across to you.
I'll double check on that. I think this micro business grant will be from 26, but we'll follow up on that.
We'll work out what the comparable periods are. Thanks, Marianne.
So this mainly probably dealt with on Thursday, but there has been some payroll tax deferrals and concessions. So a business can opt to defer any payment in the 2020 and 21 annual reconciliation return and the wages paid in July and August. There could be an interest-free repayment plan of up to 12 months, and payments can be deferred to 7th of October 2020. So eligibility for this is that it's any business paying payroll tax. So the concessions are, payroll tax concessions help reduce overheads for eligible businesses with a 30% decline in turnover. You'll be entitled to a 25% reduction in your 2021 and 2022 payroll tax. So similar with the other payroll tax deduction, you'll be eligible for your revenue decline of 30%, and you're a business with paying Australian wages up to $10 million.
Thanks, Marianne. I think the last thing we're going to touch on is around the pandemic schedule.
Yeah, so the pandemic schedule, this has been extended to the 31st of December for some awards. My understanding is there are some still awards that are applicable in the construction industry, which I'll touch up on. But what the pandemic schedule is that employees can take up to 2 weeks of unpaid leave to self-isolate, or if they're prevented from working through government or medical measures. The modern awards can differ between. So the main thing to take out of the pandemic schedule is that the employees can agree in taking a longer time frame for this pandemic entitlement. So, you could take annual leave at half pay. The modern awards will detail what notices you need to provide. Usually it's as soon as possible the employee should provide the employer, and to the best that they can predict how long they think they're going to be off work. So there are some awards that are applicable in the construction industry, such as the I think it's the Architects Award and the Aluminium Industry Awards, but majority of those that have been extended, it does relate more so towards the health sector.
Great, thanks, Marianne. And then what else will we just, I suppose we've sort of outlined what to look for. We'll leave that slide sort of there. We've talked through most of it. I think the big one for me is, if you're looking at flexible arrangements, making sure that you can do it. We'll circulate some checklists and examples of where you can find good checklists. Standing down or coming up with alternative arrangements or making employees redundant, it needs to be done really carefully. And I know we've shot through this really quickly. We are trying to cover a lot of material fast so people can get back to running their businesses and doing what they need to do. But it's something that needs to be done absolutely right. You expose quite a bit of risk to the business if you stand down people improperly, if you make people redundant improperly, or if you force people into alternative arrangements without obtaining their agreement. Obviously, sometimes tough decisions have to be made, particularly if employees aren't prepared to, for example, change their working arrangements. But that shouldn't be done in isolation. I guess if you are looking at changing the working arrangements of some people, that can't happen, and then you're looking at redundancies. You can't just then go and make the people that wouldn't change their arrangements redundant. You need to be looking at each scenario on its own merits and working through the detail. So if you've got an internal team, or obviously even other legal advisors, or if you want help from us, please let us know. But making those decisions well, I know that sounds it sounds a bit silly, but making those decisions well becomes really important. I'll flick across to the next slide. If there is any questions, put them out now. We'll wrap up in a second. I guess the context of what we're covering over the next few days from here, we've shared it through, through our mail outs as well as through our LinkedIn page. But tomorrow morning, Hamish Geddes and Matt Bryan will be working through the payment provisions that people should be thinking through. And I think that's going to be a really important session. It won't just touch on security of payment. It'll touch through other considerations that people need to think about around payment. Because if the industry has been shut down for 2 weeks, what's that going to mean to your entitlement to get paid? And if the lockdown somehow does extend, and I truly hope it doesn't, and certainly hope it doesn't need to be, what that might mean even for the assessment of claims. So Matt and Hamish will work through that in some detail in the afternoon session. So our morning sessions are at 10, our afternoon sessions are at 2, like this one. We'll be looking at, in a fair bit more detail, some of the stuff Aaron Bolton touched on Monday morning. So we'll be working through insurance at a broad, talking about that broadly, and then diving into some of the detail around business interruption and what you might be able to do under some of the policies you might have on a project specific basis, or for your business generally. We're going to be very fortunate to have Jonathan Frost. So he's at Bellrock Broking. We've reached out to him to get him to come and give a broker's perspective around what people should be doing. So there'll be legal tips as well as some practical tips from the brokers around that. And on Thursday, we're focusing on the corporate aspects of the business. So what we'll be looking at there, director duties will be, and some of the things you should be thinking about as a business. So we'll have Sally Bates and Georgia Marjorie Banks from our corporate and commercial team leading that, but they'll also have a special guest, a good friend of mine and a good friend of the business, Dan Mills, who's a director of business advisory at William Buck Accountants. So Dan will work through an accountant's perspective around those issues as well. And in the afternoon, we'll be looking at restructuring and what to do with turning around the business if it is in a bit of strife, including around insolvency issues. That will be run through by Matt Bryan, but we'll also have another special guest there. And I really do appreciate that people are volunteering their time to speak to the industry with us. That'll be Chad Rapsey. I've known Chad for a very long time, and he's the director and founder at Rapsey Griffiths Turnaround, and they're phenomenal advisors in the insolvency space. Including, one thing I really like about Chad is he thinks of proactive solutions to help businesses at the early stages before things have gone truly south, or if they're headed in that path to try and correct things. So all those people will be available, and we'll be running through that. A question that has popped up, can we get a copy of these slides? Absolutely. We're going to be circulating the recordings, as well as a copy of the slides. Our team's working to put that together, whether that's this afternoon or tomorrow. I can't tell you definitively, but we'll get them out as soon as possible. We will also circulate with or shortly after some question and answers that might be useful to you based on things that have been raised today, as well as things that get input to our team independently of this. That about wraps it up. So I just want to say thank you. Firstly, to Marianne for putting this together on such short notice. We'll notice some changes in language come through, like Marianne said, around the allow versus require employees to work from home. I really appreciate your thoughts around this, Marianne, and know that you work very closely with a lot of employers and businesses to help them with all aspects of this. So please reach out to Marianne. Jacqueline will be back on deck tomorrow. She did apologise to me that her voice is out, but so I've stepped into her shoes. So I appreciate everyone listening to what I've been trying to say, but like I said, I'm not as strong an employment lawyer as Jack or Marianne. And yes, thank you for everyone for coming in. I hope you're all well. I hope you stay safe, and I hope your businesses can continue to survive and hopefully thrive on the tail end of this. So thank you very much, Marianne, and everyone else.
Thanks, everyone.
Okay.